Hello, welcome to today's episode of Gavels and Gowns. This is a Williams-Mullen education law podcast where we explore topics that are important to leaders in education. I'm Micah Schwartz, your host for today's session. I'm a partner at Williams-Mullen in our labor, employment, and immigration section, and I am based in our Charlottesville office. Today, I'm pleased to welcome my colleague, Tom Narvaez, an attorney also in our labor, employment, and immigration section. He's in our Richmond office. Tom, would you like to introduce yourself?
Hi, Micah. Thanks for that. I'm Tom Narvaez. I'm a senior associate in the labor, employment, and immigration team, as Micah mentioned. My focus is predominantly on the immigration side. That also includes compliance and advising clients on various business immigration needs, such as visa sponsorships, path towards lawful permanent residency, and anything that arises pretty much under the immigration scope.
Thanks for that, Tom. I'm sure you're busy right now. The work you do is in all of our minds and at the forefront of what's happening in America right now, as many of us who don't focus on immigration law are focusing on it more because it's in the news so much. So we thought it'd be good to have you on our podcast to talk about, in particular, immigration enforcement activities at educational institutions. The reason, as I said, is that to begin with, President Trump during his campaign discussed his intent do mass deportations of immigrants when he became president. And then also there's been some changes in policy from what I understand, putting some of his intentions into action that I'm going to ask you about. Let me say at the outset that we're going to focus primarily on these kinds of immigration activities in higher education and at college and university campuses in particular. But most of what we're going to discuss would apply to K-12 schools as well. And when we get to places where the answers are likely to be different for the two, we'll try to point it out. But why don't we get into it? I'm sure that a lot of our listeners, Tom, are familiar, again, that there's been changes in federal policy towards immigration enforcement activities and changes in priorities and also changes in how those kinds of activities might occur at educational institutions. But most of our listeners probably don't know the details. So could you give us some more details?
Yeah, so one of the biggest, hot topics right now is what is the current administration doing in terms of enforcement? The Trump administration made it very clear that they are prioritizing the removal of individuals that do not have lawful status in the United States. And under the Biden administration, there was guidance regarding protected areas and enforcement priorities for immigration customs enforcement, meaning certain locations, protected areas, were off limits for immigration customs enforcements to take removal action or really any type of enforcement action to remove individuals from the United States. And that resulted in, schools, universities, other localities adopting policies which, oftentimes will be referenced as sanctuary cities or, establishments that are a sanctuary. That included schools, churches, also protected areas included courthouses. That has gone away. That was one of the first executive orders under the Trump administration that removed and rescinded that Biden era policy. So what does that mean right now? Well, the protected areas memo is gone. So any guidance or policies that were developed previously relying on that memo, it holds no weight for the current administration. And as the current administration has made it clear, their focus is enforcement and removal of individuals that do not have a lawful basis to remain here. So that means that now is the time for individuals, for, institutions, all the relevant parties to be proactive in ensuring that they are complying with the different developments that are occurring.
All right, thanks for going through all of that. So I understand from what you're saying that it was the approach of the Department of Homeland Security and its agencies to refrain from committing enforcement activity in certain areas that the previous administration deemed to be sensitive, like you said, churches and schools as an example, and that's now gone. Does that mean that there is a particular intention to do enforcement activities at those places? Is there actually prioritization in those places, or are we now just dealing with the absence of what was a previous kind of protection for schools?
So that's a very good follow-up. There's a lot of litigation that's ongoing with all these different changes. The administration has said that, the enforcement agencies are to use common sense. While we don't expect immigration customs enforcement to come knocking on a K through 12 on a kindergartner's, classroom or something of that sort, it's now the time to just be proactive in having a plan in place because as the administration has said, the priority is enforcement. And now that that prior Biden era guidance is gone, enforcement agencies really have a mission of making sure that they're removing individuals that are removable from the United States. And while the administration has said, hey, enforcement agencies use common sense, that's very subjective. So we don't exactly know what they will and will not be including in those areas. So that's why it's critical right now for everyone to be proactive in terms of having a plan in place, understanding compliance when it comes to immigration enforcement, and like I said, having a plan in place.
Yeah, thanks for that. I'm always wary when someone says to use common sense because I think that there's not always such a consensus about what that sense is. Right. So I understand. I mean, it sounds like those who run educational institutions are going to be dealing with something that they haven't really dealt with, at least over the course of the last few years, maybe even a decade, which is immigration officials showing up on campuses with intent to do enforcement. And that means they're going to be dealing with interacting with ICE agents in a way that they probably haven't before and trying to decipher the types of documentation that the agents are putting in front of them. And what I'm referring to here are subpoenas and warrants, which are the tools that government agencies typically use to try to either come into a place and look for something or look for someone, or to get records that are relevant to whatever the government's looking for. So I'm wondering if you could maybe explain some to the audience, this distinction that a lot of us are probably having to become more familiar with because we're, again, dealing with this for the first time in a while. What kind of documentation would we expect agents to have when they come on campus? How do we know that they're legit? And are there kind of gradations in seriousness about kind of like what we have to allow the agents to do when they come, depending on whether they have a warrant or a subpoena or something like that?
Yeah. So really, it boils down to having the right training in place and understanding the differences between judicial warrants, or I should say judicial actions versus administrative actions, whether that's a warrant or a subpoena. So when dealing with a judicial warrant or a judicial subpoena, these are issued by judicial courts. You're going to have a document that's been signed off by a state or federal judge. It's going to specify with particularity the action that's going to be taken. And when you're presented with a judicial warrant or a judicial subpoena, you must comply. That is a judicial order. Not complying with a judicial warrant or subpoena could result in you being held in contempt of court. Now, in contrast with an administrative warrant or an administrative subpoena, these are not issued by judicial courts. Instead, these are issued potentially by the Department of Homeland Security or other federal agencies. They're signed by an immigration officer or another federal officer within that agency. And these administrative actions, administrative warrants or administrative subpoenas, you really want to have a plan in place when dealing with this, making sure that you have counsel that you can reach out to, making sure that you are taking proactive approach when faced with these administrative actions, because this is not a order from a court. So if you're presented with an administrative warrant, that doesn't come with the same weight and authority that a judicial warrant or subpoena comes with. So that's why it's important to understand the differences between those and what a federal officer or an enforcement officer can and cannot do if they have an administrative warrant or an administrative subpoena.
All right, thanks for going through that distinction. I assume to some extent the officials at schools will just have to interpret what they see, right? They won't know it until they get it, and if they do and they have questions, they should consult with their attorney to try to get a better sense for what the agents are asking for. Why don't I pose a question to myself and then answer it quickly, because this is in an area that I work in a lot, which is FERPA, which I think a lot of our audience will be familiar with, the Family Educational Rights and Privacy Act. And it comes into play, I think, not in terms of the actual kind of deportation efforts that we've been talking about, but rather if government agents are asking for records about students. Also, less so for employees. I think it's possible that agents will be asking for information about employees, but frankly, a school's obligation to protect information about employees is less intense than its obligation to protect the privacy of its students because of FERPA. And so this is a circumstance where we're dealing with basically government authorities working crosswise of each other. Federal agent asking us for information, and meanwhile, a federal law saying that we're not supposed to be providing information easily about students. And our clients are going to have to figure out how to navigate this. So maybe I can give a couple of tips. The first point here is that FERPA is pretty wide ranging and doesn't include that many exceptions. So I think a lot of people probably think that FERPA has a general law enforcement exception, meaning, yeah, we need to maintain student information, but if a government official asks for it, surely that's an exception. And it's not. Instead, if you look at the exceptions, there is something like a law enforcement exception, which is a health or safety emergency exception. And so often when we're dealing with the government, we're dealing with emergencies. It's the police who are asking for information so they can help locate somebody or something like that. But I think in most cases, if ICE, the Immigrations and Customs Enforcement Office of the federal government, is asking for information about a student, I don't think it necessarily will be a health or safety emergency, or it will at least be incumbent on ICE to explain how it is. And so I think in most cases that exception isn't going to apply. And in other words, just because an ICE agent asks for information doesn't mean that we can give it under FERPA. I think that FERPA would allow for producing records in response to requests from the government, but only, I think, if there is either a subpoena from, again, the government officials or a court order. So in other words, if there isn't a subpoena or a court order, we not only wouldn't need to produce records in response to ICE, but would probably actually be violating FERPA if we did. If ICE presents a subpoena or a court order, then I think it would be okay to produce records to those officials. But even then, we've got a hoop to jump through, which is we're supposed to inform, in a case of college and university, the students. If the kids are over 18, basically we're supposed to ask the students, and they will be in most cases for colleges and universities. And then for our K-12 clients, those kids are primarily going to be under 18. So in those cases, we're asking the parents. But basically, in both cases, we have to notify the students or the parents that we've got this subpoena and that we intend to respond to it in case they want to take some kind of effort to quash the subpoena. All right. So after posing and then answering my own question, let me go back to posing a question to you. So we've been talking about kind of changes. You've been talking about changes in federal policy. Now, why don't we kind of turn to how they're going to be enforced? You've been describing, again, ICE agents coming to do deportation efforts at universities, but the rubber is going to hit the road at some point, and it's possible that they might get turned away at a university or a college or a K-12 institution, which begs the question, then what? Would our clients expect that they might be prosecuted for impeding investigations of this kind? Have we gotten any kind of insight from the Federal Department of Justice about how it would respond to that kind of circumstance?
Yeah, great. Thanks for that, Micah. So this is a very fluid situation. And of course, we're still within the early days of the Trump administration. So there's a lot of different pieces of litigation moving through the justice system. But DOJ has made it clear that localities and folks that are impeding on lawful enforcement actions, DOJ is going to look into those actions. Attorney General Bondi has made it very clear that the U.S. attorney's offices should look into instances where individuals are impeding on lawful enforcement actions, especially for these removals. So whatever protocols, whatever policies and response plans that are in place, it's important for universities and individuals to understand their risk tolerance. Or if you know that you're adopting certain policies that might be deemed sanctuary under the current administration, it's important to understand what that risk tolerance is. And if litigation were to come up Are you prepared? Do you have the resources in place to navigate that? So that is very important to understand. And again, it's a fluid situation. This is changing. There's a lot of different moving parts right now through the various courts. So it's important to just understand and be proactive with all the different developments that are occurring right now.
All right, thanks, Tom. Why don't we talk also about international students in particular? These are going to be less of a concern probably for our for K-12 listeners, but those in higher ed who have international students, what kind of guidance would you provide either to the institution or to the students themselves, given the change in climate?
Certainly one of the other hot topics. So when it comes to immigration enforcement, there's a lot of focus on the removal side. But really, when it comes to immigration, there's many other areas that are going to be of focus. International students and non-immigrants, that's definitely another area of focus. Just recently, there were changes in terms of who was eligible for obtaining a Dropbox appointment to obtain a visa while traveling abroad. But why does that matter for, higher ed institutions? Well, universities with an international student population, it's important to have open communication and making sure that F1 students are communicating with the designated school officials. Because if they were to travel back home to maybe visit family and while they're abroad also obtaining a new F1 visa to then subsequently re-enter the United States, it's important to understand the climate of where they're going back to and what the consular operations are at that time. So a recent example would be an individual departed from the United States because they had a Dropbox appointment. A Dropbox appointment is you met certain criteria, you already had a visa, and now you're just going back to renew said visa. While under the new guidance that changed with very limited advance notice, and it was not communicated well, that individual left, was under the impression they had a Dropbox. That's no longer the case. Now they had to book an appointment, and the next available appointment this individual was able to secure is in April. Again, they were expecting to process this in mid-February and have the visa by the end of February, early March. Now they're facing that they can't even get in front of a consular officer until April, and then they have to wait for the visa, and then they can subsequently re-enter the United States. So that is a significant delay. So that is why it's critical right now to communicate with international students, making sure that individuals are aware of the fluid situation with consular operations and the fact that immigration priorities are changing. You have the Secretary of State who is rolling out their agenda. Department of Homeland Security, they're working on rolling out their agenda. There are going to be a lot of changes coming up, and oftentimes with very short notice. So it's critical to be proactive, understand the fluid environment that we are in right now, and just communicating. So it's also important for universities and higher ed institutions with international student populations to have the right training for their DSOs, the designated school officials, making sure that the record keeping is complying with the various regulations, making sure that F1 students are not violating the terms of their non-immigrant status, making sure that I-20s are being updated accordingly, that the CVIS records are being kept accordingly. So that is all extremely critical right now.
Yeah, that sounds like it would cause some major hiccups at universities, I would think, for international students. Why don't we shift in our final topic to focusing on employees for a moment? We've been focusing again primarily on students and impacts on them and the ways in which the universities need to manage their relationships with their students. Why don't we shift here at the end to employees and things that our education clients need to be focused on when it comes to their employees? I'm thinking primarily here about Form I-9s and potential audits that they could be doing internally or that we can expect the government to be doing for them. So do you have any guidance for our clients and the others listening about things they should be focusing on when it comes to Form I-9s? And maybe a lot of our audience probably doesn't know what an I-9 is, so maybe you could explain that piece too.
Yeah, so I-9 compliance, I expect, is going to be the next hot topic and priority for the administration. As I mentioned earlier, one of the priorities is, enforcement of removal actions. But at the same time, and the overarching theme with the administration has been, do individuals have work authorization? Are they legally able to work in the United States? Well, the way to verify that is through the Form I-9 compliance. And this came about during the Immigration Reform and Control Act of 1986. And employers are required to complete the Form I-9 within 3 business days of hiring of the first date of employment for the employee. And what this document does is it verifies the identity and work authorization for the individual. And Form I-9 compliance is very meticulous and it's very easy to have an oversight and not be in compliance. So an easy example would be if the employee completed their portion, then the HR department completed section 2, but they didn't sign off until 5 days later, or they realized that they completed it, but it just wasn't signed, or it was signed or and it wasn't dated. If it wasn't within 3 business days of the date of hire or the first date of employment, that I-9 is now at issue. The other issue that would come about would be you hire somebody that has temporary work authorization and they require a re-verification, but you were using a system that might not have alerted you to re-verify that individual. Well, now you potentially might have somebody that no longer has work authorization and they continue to provide services for the university. So you now have somebody working for you that does not have work authorization. And that's where these I-9 issues really come about. So, what does this mean for universities and institutions of higher education? Now is the time to be proactive, conducting internal I-9 audits of your Form I-9 records, making sure that there's an I-9 on file for each employee, and making sure that they were completed timely, identifying if Section 2 was completed timely, that you have the documents needed in the file. If you're enrolled in E-Verify, there are certain requirements for document retention. So making sure that those documents are in the individual files, making sure that if you use electronic signatures, that those are in compliance with the I-9 rules. Additionally, if you have electronic storage, there are specific guidance and requirements for when electronic storage of I-9s is in compliance or not in compliance. So now is the time to be proactive in conducting these internal audits. And if you have not navigated one of these internal audits before, reaching out to outside counsel or necessary counsel to provide that advice, provide that training, making sure that the HR individuals or individuals responsible for completing the I-9s have the necessary training to ensure that I-9s are being completed accurately, they're complete, and making sure that the I-9 program is compliant.
Well, thanks, Tom. I think we've given our listeners a lot to think about. So I think that's probably a good place to wrap up. Thank you for joining me today.
Thank you for having me.
Absolutely. And thank you to our listeners also for tuning in to another episode. If you have questions about what we've talked about or suggestions for future episodes, then please reach out to us. You can do so easily by going to williamsmullen.com, our website, and there you'll find an education page that provides our contact information and explains the kinds of services that we provide to clients. You'll also find out more about our teams and the types of legal services we provide to those in the education industry. And finally, when you're there, you can subscribe to this podcast to make sure that you get future episodes pushed out to you as soon as they're ready. Thanks again to everyone for joining, and we look forward to talking with you again. Have a nice day.